Asadallah masa'akum bikulli khair. Welcome, everyone. Before I start, if you're sitting in the back, it would be great if you could move forward. I hate to bother you if you've already become comfortable, but we're a smaller group today, so it would be good to foster a bit of community. Welcome, everyone. My name is Maurice Pomerantz. I'm the director of the NYU Abu Dhabi Institute, which is an interdisciplinary center for advanced research, artistic creation, and public outreach. I'm also a professor of classical Arabic literature here at NYU Abu Dhabi. This lecture is one of the, I believe it's our penultimate talk. Tomorrow night, I wanted to tell you all about another event which the Institute is co-sponsoring along with the Sheikh Zayed Prize. It's a panel highlighting two recent winners of the Sheikh Zayed Awards, and in both cases in literature. The panel will be discussing Arabic literary culture in Southeast Asia in the 17th and 18th centuries. Why is it featuring that topic? Well, the award-winning book this year addressed this, what might seem at first to be a very unknown topic for many of you. But I promise it will be a very interesting and lively conversation. He'll be joined on stage by Professor Reem Bassiouni, who's a sociolinguist and renowned author of several recent award-winning novels, including an absolutely remarkable novel on the life of Abu Hamid al-Ghazali, one of the great jurists, thinkers in jurisprudence of the Islamic tradition. It's a gem of a novel. I'll be the moderator for this event, and I hope you'll be able to make it out to the Abu Dhabi Convention Center at 7 p.m. tomorrow night. It'll be on the main stage. And of course, there are many other exciting programs at the book fair going on right now and for the next couple of days. So I hope those of you who are interested make it out there. For now, though, it's my distinct pleasure to introduce you tonight to our moderator, Dr. Pavlos Eleftheriadis is a professor of legal studies at NYU Abu Dhabi, an affiliated professor at the NYU School of Law. He teaches and researches in the philosophy of law and in public law. Before joining NYU, he was a professor of public law at the University of Oxford. His current research interests are in ethical theories of law and in climate justice, and he remains a senior research fellow at Mansfield College, Oxford. And with that, I leave the floor to you. Thank you so much.
Thank you, Morris, for this very kind introduction, and thank you to the Institute for providing us this opportunity, giving us the floor to invite lawyers. And it's the third law event we're holding in this place, so we're very grateful. We have great plans. We won't have even more of those events in the future. Let me say a couple of things about our program. The Legal Studies program at NYU Abu Dhabi is a small program. We're about 7 or 8 people in the faculty. Our student numbers are rising very fast. I think we have 144 students at the moment. We are in a position that is slightly unusual. I mean, my previous institution, Oxford has teaching of law for centuries, and it's a very well-established program. Here we're a new program. It started in 2018, and we joined the liberal arts program of an American institution. And we're very ecumenical. We teach law as well as many other things, and that's actually very interesting. I find it interesting, but in a certain way also challenging, because you don't know what your students expect from you. They don't have a certain structure that you have in a standard legal education. The second distinctive feature of our position here in Abu Dhabi is that we're not a jurisdictional law school. We don't teach the law of the UAE. We're not expected to. We teach in the English language. But we also don't teach American law. We don't teach US law. What do we teach? So we teach a mixture. We're very ecumenical, comparative, and international. And we have realized that we are actually a very convenient location to invite scholars in law from various traditions in the region. So the Middle East, South Asia, perhaps Africa, South Africa, Kenya. What is also very convenient for us that in many of these jurisdictions operate in English. So this is our hope and our aim, to encourage these conversations among legal scholars. And it's obviously important to bring academics, but it also, and we have done so in the past, our previous events, but it's also important to bring people of practice, men or women of practice, practitioners and judges in particular with long experience, because they can actually tell us different things about practice. And some of them, especially judges in here and in South Asia more generally, have had to deal with political polarization and instability that other judges in Europe or in the US until recently haven't actually experienced. So they have a lot to tell us about how a court remains legitimate and how it remains relevant, how it solves problems, how it interprets the Constitution wisely and prudently. So that's what I want to hear from practitioners in our region. So that's why I've invited our today's guests, and I'll say a couple of things about our guests, and then I'll give them the floor for about 20 minutes each one of them. Then we can have a discussion amongst us, and then we'll open it to the floor for question and answer. So our first speaker is the Chief Justice of Bangladesh, Justice Syed Refaat Ahmed, and he has a very distinguished CV. He's been the Chief Justice of Bangladesh since August 2024. He was educated in Dhaka, Dhaka College and the University of Dhaka, where he completed his LLB. But he continued, I'm not sure why, to the University of Oxford, where he did a law degree at Wadham College in English law. And he continued still to do a master's and a PhD at the Fletcher School of Law and Diplomacy at Tufts University. He returned to Bangladesh to practice law, and he was appointed to the High Court in Dhaka 2005, and he was elevated to the position of Chief Justice a few months ago. So welcome, Chief Justice. Our second speaker is Dr. Ananda Mohan Bhattarai, a recently retired Justice of the Supreme Court of Nepal, where he sat from 2016 to 2024. He's studied law and political science in Nepal at Tribhuvan University. He continued his legal studies in India at the National School of India in Bangalore, where he pursued an LLM and a PhD. And he has a distinguished career as a judge, starting as district judge, continuing at acting chief judge of the Court of Appeal of Tulsipur from 2013 to 2014, chief judge of the Court of Appeal 2014 to 2016, and justice of the Supreme Court from 2016 till I think 2024, very recently retired. So Dr. Ananda Mohan Bhattarai, welcome to NYU Abu Dhabi. So as I said, 20 minutes each, and then we'll have a panel discussion. You have the floor. Thank you.
Mr. Justice Ananda Bhattarai, retired Judge, Supreme Court of Nepal, moderator of today's event, Professor Pavlos Eleftheriadis, Professor of Legal Studies, NYU Abu Dhabi, esteemed faculty, learned jurists, distinguished students, ladies and gentlemen. It is a privilege to be here at NYU Abu Dhabi to share with you the Bangladeshi juridical and constitutional perspective on the climate crisis. It is a truism that we are in the grip of a planetary emergency. The Earth is warming, oceans are rising, biodiversity is eroding, and livelihoods are collapsing. The Intergovernmental Panel on Climate Change confirms that anthropogenic greenhouse gas emissions, primarily from fossil fuel combustion, deforestation, and unsustainable industrial practices have altered the planet's climate system in irreversible ways. Yet, this crisis is not equitably borne. In stark contrast to economies that are largely responsible for CO2 emissions, countries of the global south, whose people continue to suffer from floods, droughts, rising sea levels, and food insecurity, have contributed insignificantly to the problem. This is not merely a climate crisis. It is a justice crisis. And this is where the vocabulary of climate justice finds its deepest meaning. Climate justice demands a reordering of our moral and legal compass to reflect that those least responsible must not continue to pay the highest price. It asks us to frame environmental degradation as not only a scientific and economic concern, but also as a profound violation of human dignity, of sovereign equality, and of intergenerational responsibility. Environmental justice has first emerged in the 1980s in response to toxic dumping in African American communities in the United States of America. The concept evolved to encompass equitable treatment in environmental governance, meaningful public participation, and access to judicial redress. Climate justice has emerged as its natural successor. It calls for equitable responsibility, historical accountability, intergenerational equity, and ecological reparation. Dear participants, the People's Agreement of Cochabamba 2010, the Durban Declaration, and the advocacy by grassroots coalitions such as Climate Justice Now have shifted climate discourse from the realm of emissions to the realm of ethics. These instruments and movements converge on principles such as the right to development without degradation, protection of indigenous cultures and knowledge systems, restoration of ecological damage, and rights of nature, and the doctrine of ecological trusteeship. The Yasuni ITT initiative in Ecuador and the Universal Declaration of the Rights of Mother Earth are both instances where this shift from anthropocentric to earth-centric constitutional imagination has gained real traction. It is within this crucible of advocacy, science, and jurisprudence that constitutionalism must now respond. Constitutions, though products of national sovereignty and being essentially social compacts, are increasingly global in their aspirations. Environmental protection provisions have found their way into over 150 constitutions globally, often under the influence of the Stockholm, Rio, and Johannesburg declarations. In South Asia, this trend is particularly vivid. Bhutan mandates 60% forest cover in perpetuity. Nepal guarantees a right to a clean environment and food sovereignty. India enshrines environmental duties under Article 51 AG, with judicial interpretations reading the right to a healthy environment into the right of life under Article 21 of their constitution. Sri Lanka, Maldives, and Afghanistan have all adopted ecocentric constitutional norms. Bangladesh, I submit, represents both the urgent case for and the transformative potential of constitutional environmentalism in the global south. And why is that? That's because Bangladesh is arguably ground zero for climate vulnerability. With 82 internationally recognized wetlands, the world's largest contiguous mangrove forest, i.e. the Sundarbans, and one of the most densely populated deltaic geographies on the planet, our nation exemplifies environmental fragility. We also have a climate-induced migration, which is emerging as a critical challenge in Bangladesh. with rising sea levels and frequent cyclones displacing millions from coastal regions. Research indicates that by 2050, that's in about 25 years from now, over 13 million Bangladeshis would be forced to migrate internally due to climate change impacts, particularly salinity, intrusion, and river erosion. Bangladesh, unsurprisingly therefore, has introduced Article 18A into its constitution, which reads, and I quote, "The state shall endeavor to protect and improve the environment and to preserve and safeguard the natural resources, biodiversity, wetlands, forests, and wildlife for the present and future citizens." End quote. Simultaneously, Article 23 of our Constitution mandates the preservation of indigenous cultures intimately connected with nature. These are noble constitutional declarations, but they reside under the constitutional provisions categorized as fundamental principles of state policy in a particular part and chapter of the Constitution, which under Article 8.2 of the Constitution are declared non-justiciable or non-enforceable. Yet, our judiciary has refused to be deterred by this. In the seminal case of Dr. Mohiuddin Farooq versus Bangladesh, the Supreme Court legitimized public interest litigation in environmental matters. Later cases, including Wahab versus Secretary, Ministry of Land, and Major General K.M. Shafiullah versus Bangladesh, expanded the interpretative reach of environmental principles. The courts have over time gradually translated aspirational directives into binding norms, invoking the doctrine of legitimate expectation and the public trust principle as judicial mechanisms of accountability. The Supreme Court of Bangladesh in 2019 reaffirmed this trajectory in a landmark case concerning illegal encroachment and pollution of the Turag River. The court not only invoked the public trust doctrine, but also directed executive agencies to update enforcement mechanisms in line with scientific data and climate projections. By treating the rivers as legal entities, the judgment expanded the horizons of environmental law and firmly embedded ecological protection within the fundamental human rights framework, thus setting a transformative precedent for environmental governance in the era of climate crisis. In another case from 2022, the court upheld the rights of forest-dwelling communities to participate in environmental impact assessments, reinforcing procedural justice within ecological governance. In the case of Bangladesh Environmental Lawyers Association versus Bangladesh and others, being an author judge, I have discussed the critical necessity for Bangladesh to uphold the universal application of internationally competitive rules on environmental protection, particularly in the hazardous and high-risk industry of shipbreaking. As highlighted in the judgment, the legal framework in Bangladesh, including the Shipbreaking and Recycling Rules 2011, the Hazardous Wastes and Shipbreaking Waste Management Rules 2011, and the obligations under the Basel Convention, has been designed to mirror and adopt global environmental standards. In that judgment, I emphasize that any deviation from these stringent norms, especially in the form of regulatory leniency, false declarations, or inadequate enforcement, exposes Bangladesh to becoming a dumping ground for hazardous waste in violation of Article 18A, as I just quoted to you, and Article 31, which mandates upon the state to ensure the protection, extend the protection of law to every citizen, and the right to life. By insisting on strict compliance with environmental regulations, mandating inventory of hazardous materials prior to import, and condemning the practice of acting with impunity under a lax administrative regime, the court in that case reaffirmed the imperative for universal application of environmental standards. Such alignment with global norms is not merely a matter of domestic legal compliance, but a constitutional and increasingly humanitarian necessity to safeguard public health, worker safety, and environmental integrity in an increasingly interconnected world. Bangladesh has also enacted robust legislation. We have the Environment Conservation Act of 1995, we have the Environment Code Act of 2010, we have the Wildlife Conservation and Security Act of 2012, and the River Protection Commission Act of 2013. Yet, enforcement remains uneven, hindered often by bureaucratic inertia and lack of adequate environmental tribunals and technical resources. Esteemed participants, let us now examine the comparative experiences of the countries of the Global South. Argentina's Section 41 affirms every inhabitant's right to a balanced environment and obliges polluters to repair environmental damage. Vietnam's 2013 constitution, through Article 43, articulates the right to a clean environment and the duty to protect it, embodying civic environmental responsibility. Indonesia's Article 28(1) enshrines the right to live in prosperity and enjoy a healthy environment coupled with affirmative action for equity. South Africa's Constitution affirms in Section 24 that every person has the right to an environment that is not harmful to their health or well-being. South Asia's courts have emerged as laboratories of climate jurisprudence. The Indian Supreme Court in Vellore Citizens Welfare Forum and versus Union of India championed sustainable development. In Asghar Laghari versus Federation of Pakistan, the Lahore High Court held the government liable for non-implementation of its climate adaptation framework. Nepal's courts have invoked the precautionary principle to halt development projects which jeopardize ecological balance. Sri Lanka's judiciary has intervened in deforestation-related disputes and in safeguarding wetland ecosystems. In Bangladesh, we have broadened Article 32 that encompasses the notion of the right of life to include environmental protection and environmental rights. Recent rulings have addressed industrial waste dumping, river encroachments, and air pollution in Dhaka. In a 2021 case, the High Court Division of the Supreme Court of Bangladesh imposed strict liability on a multinational corporation for mercury contamination in groundwater, recognizing the linkage between ecological harm and fundamental rights. Dear participants, the Paris Agreement of 2015, though ambitious, is constrained by weak enforceability. Articles 2 and 4 speak of nationally determined contributions, but the use of should in Article 4.4 instead of shall waters down legal obligations. Financial flows, technology transfer, and adaptation support remain ambiguous. Post-2015, successive COPs have aimed to operationalize the Paris framework. COP26, where our countries agreed to phase down coal and double adaptation finance. And there's COP27, which achieved a historic breakthrough in establishing a loss and damage fund to support countries suffering irreversible climate impacts. COP28 in Dubai 2023 introduced the global stock take, a mechanism to assess collective progress towards limiting warming to 1.5 degrees Celsius. Yet, and it is a truism, we all know this, implementation lags behind ambition. As of early 2024, the Green Climate Fund remains underfunded, and the operationalization of the Loss and Damage Fund faces institutional delays and political wrangling over eligibility and governance. Bangladesh has led regional efforts under the Climate Vulnerable Forum, hosting dialogues and piloting climate litigation models. In November 2016, Bangladesh hosted the 5th South Asia Judicial Conference on Environment and Climate Change in Dhaka, co-organized by the Supreme Court of Bangladesh and the Asian Development Bank. This landmark event, which Justice Bhattarai was gracious enough to attend at our invitation, convened judges, legal experts, and environmental practitioners from across South Asia to address pressing environmental challenges and the escalating impacts of climate change in the region. The conference emphasized the critical role of judiciaries in promoting environmental adjudication, enforcement, and justice, fostering a collaborative approach to developing legal frameworks and judicial responses to environmental issues. Our judiciary has supported executive commitments under the Climate Prosperity Plan, linking economic recovery to low-carbon development. Bangladesh has submitted an updated NDC, which is a nationally determined contribution focusing on renewable energy, climate-smart agriculture, and resilient infrastructure. Institutionally, Bangladesh pioneered South Asia's first environment court as early as in 2002. Though restructured under the 2010 Act, the court continues to face structural challenges. Against this general context, we must reimagine constitutionalism. Constitutionalism must be ecologically literate. Environmental rights must become actionable. Governance has to be transparent, and civil society has to be empowered. The climate crisis compels a profound civilizational shift from anthropocentric to ecocentric paradigms, challenging humanity to reconsider its place within the natural world rather than above it. It invites jurists, academics, policymakers to fundamentally redefine the notions of development, justice, and citizenship through a prism that honors ecological balance as the foundation of human flourishing. In this reimagining, the richness of indigenous knowledge systems rooted in stewardship, intergenerational equity, and coexistence emerges as indispensable, offering models of sustainable living in that modern frameworks have long marginalized. The crisis simultaneously elevates the role of actors like municipalities, provinces, and grassroots movements as frontline innovators of climate adaptation, resilient urban development, and employment strategies designed for a just transition from a pre-climate crisis scenario to a post-climate crisis scenario. And I make this argument in terms of the inevitability of the massive dislocation that is going to be caused internally within Bangladesh by reason of climate migration, and which will resonate, which will have serious repercussions across transnational borders and South Asia in general. As extreme weather events, sea level rise, and resource scarcity displace millions, climate-induced migration has become not merely a humanitarian issue, but a profound justice challenge, implicating the fundamental right to life enshrined in the Constitution and international human rights law. Jurisprudence of life, liberty, and dignity must now accommodate the right to climate-resilient shelter, secure livelihoods, and sustainable urban spaces that can absorb displaced populations without replicating cycles of marginalization. In this evolving order, there is an urgent call for a global fiduciary standard, one that transcends territorial borders, to hold historical and contemporary polluters accountable, and to redistribute obligations in ways that recognize shared but differentiated responsibilities. Without embedding these principles into the heart of law and governance, the promise of climate justice, I'm afraid, will remain a hollow aspiration rather than a living reality. Let legal academia, especially in cosmopolitan institutions like NYU Abu Dhabi, lead this renaissance. Let us cultivate a generation of jurists who will write, argue, and advocate for the planet. Let's build legal architectures that will outlast climate denial and withstand political inertia. Climate justice, ladies and gentlemen, is no longer a deferred ideal. From the Bangladeshi perspective, it is a constitutional imperative. Let us rise to meet it. Thank you very much.
Justice Bhattarai, please. Thank you, Professor Pavlos Alfreadis. My very respected brother, Chief Justice Refaat Ahmed, and Professor Morris, Professor Craig, and distinguished participants. It's a real pleasure to be here. I would like to extend my sincere thanks to NYUAD and the team associated with organization of this dialogue. This is my first visit to this great country, the heart of Arab civilization. Nepal and UAE had established diplomatic relations in 1977 and have been close friends since then. Recently, your Deputy Prime Minister and Foreign Minister, His Excellency Sheikh Abdullah bin Zayed Al Nahyan, visited Nepal, and we are fortunate to welcome him there. Coming to the theme of this program, I was wondering what to write and what to deliver. Then I just looked at the invitation sent by Dr. Pavlos, and in the invitation I saw 4 questions. First, what role does law have in securing climate justice? Second, can substantive conception of environmental rights make a difference? Third, does the Constitution have anything to say about green transition? And fourth, can a Supreme Court assist this process by providing safeguards of fairness and legitimacy? These were a very brainstorming question for me, and I assure you that I have waved my thought along these questions. But before I go, I make my dive into these questions, I would like to bring your attention and bring to your mental map the landscape of Nepal. A small, I should say not a small, but a moderately sized. I was talking with Professor Pavlos and comparing Nepal with European countries. Belgium or Greece, almost of that size. So in physical size, it's not a big country, but population-wise, around 30 million people are living in my country. And this country is facing enormous climate change-induced challenges. We are bordered by two giant neighbors, China and India, who are gigantic, not just physically or demographically. They are gigantic in terms of greenhouse gas emission as well. But, and contrast that to the greenhouse gas emission of Nepal, 0.27%. And the trouble that we are facing. It's not that when you talk about climate change, it's not just immediate neighbor. It's it could be even South Africa affecting the climate. Or historically, it may be like 50 years back, the emission was there and the globe is warming. But again, what is happening in our neighborhood is a matter of concern. And Nepal, you see, I come from the mountain. I'm not a city dweller. In my childhood, I used to fly kites, thinking that one day my kite will reach the mountain, Himalayan peak, around Pokhara. It's in western Nepal. That didn't take place because from my village, the mountain peak was 25 miles of crow flight distance. So which, it is not possible for a kite to reach there. Mm-hmm. But in my imagination, I used to think that it will reach there. Now, after retirement, I've started living in that mountain again. So I'm straightway coming from the mountain and telling you the stories of what is happening there. The lot of bad things are happening. It's not only the glacial lake melting, the melting of permafrost, which is down deep in the aquifer. When it melts, the whole mountain range collapses. It's not just the glow, what is happening there, the collapse of the mountain. And in the high mountain area, the water has dried up, and the whole village is migrating out. And interestingly, there used to be, Chief Justice, there used to be no dengue in Nepal. Now, everywhere in the mountain, there is dengue, spread of dengue seasonally. Oh. And mosquitoes, during my school, I was there up to my high school days. We didn't have mosquitoes in my village. Now, mosquitoes and dengue. The mosquitoes bringing dengue and malaria are climbing up to the tree line in a district like Mustang. This is in the rain shadow area in the mountain. So there is dengue there. And floods and winds, about winds, So the winds have become so forceful that during winter, when there is fire in the jungle, so its ferocity is so much because of the wind, fast-blowing winds. So many, and then crop failures, and wildlife people conflict, all those things are happening. And in October 23, UN Secretary General visited Nepal. And before he spoke to the parliament in Kathmandu, he went to the high mountain areas. And he said, after that, he said in the parliament, and I quote, "What is happening in this country as a result of climate change is an appalling injustice and a searing indictment of the fossil fuel age. I am deeply concerned by those communities in Nepal facing the brutal impact of climate crisis." Now in Hague, ICJ is deliberating on advancing advisory opinion on climate crisis, climate justice. And Nepal got an opportunity to voice the grievances. And our foreign minister said, Nepal is victimized for no wrong or crime created by it. So this is the story. But there is some silver lining. In the last 10 years, Nepal has made good progress in producing hydroelectricity. The installed capacity of hydroelectricity and solar energy is over 3,000 megawatt. And we are exporting surplus electricity to India and a bit of it to Bangladesh also. And there is EV boom in Nepal. So around 70% of the vehicle, imports of vehicle is EV. And surplus electricity is also influencing our kitchens. Induction heaters and utilities are growingly purchased by in Nepali houses. Third, the growth of community forest. In the 80s, there used to be a story about the forest loss in Nepali mountain. World Bank and the alarmist academia said that by 2000 there will be no forest in the Nepali mountain. But that was not true. And now we have 45% of our area land mass covered with forest. So this small, we are positively contributing to the reduction of greenhouse gases, whatever we could do in Nepal. Now turning to the constitutional landscape, Nepal adopted a new constitution in 2015. Seventh constitution in a span of 70 years, around 70 years. My professor in Germany used to ask me, 3 generations is struggling for a democracy. Is it possible? I used to tell him, Professor, you should congratulate Nepalese for their faith in democracy and rule of law. And this constitution has one of the youngest, this is the youngest constitution in South Asia, has benefited from a lot of exercises of the judiciary in South Asia. What our brothers and sisters in South Asia call as judicial activism is a constitutional duty of the court in Nepal. It is enshrined in the constitution itself. This constitution has a very bold framework of right, first. Second, the state is obligated to frame legislation to operationalize those fundamental rights within 3 years, and which it has done. And where it fails, since this is also a fundamental right, petition may be filed in the Supreme Court. And as to the judiciary, the Constitution has really secured the independence of the judiciary and almost, by and large, the functional autonomy of the judiciary. The Supreme Court is the custodian of the Constitution, the final interpreter of the Constitution. And since the Constitution unveils an inclusive democracy in Nepal, I think this term is, for the first time, is used in any of the South Asian constitution. Inclusion is the signature tone of our constitution. So it is the inclusive roadmap that the constitution has prepared for, dictated for all of us. And in this constitution, as my brother mentioned, a right to a clean and healthy environment is guaranteed as a right. I emphasize on the term healthy in order to realize right, you can realize right in an environment. And if it is healthy, there is a possibility of realization of rights. And if the rights are violated when environment is harmed, there is such a direct link to that. So it is not only declaration, it also creates entitlement to the people for claiming compensation against pollution and environmental degradation. By the term expression environmental degradation, you can link it to the climate change. Because when climate change occurs, environment gets degraded. So this is how the Constitution is linked to climate change. And thirdly, the directive principles of the state policy. Professor Ivor Jennings was in Nepal, advised the king to draft a new constitution, though not a very democratic one. But then directive principles were enshrined in the constitution. And this new constitution has a very broad provisions on directive principles that talk about land protection of land, protection of water resources and renewable energy, disaster management, and biodiversity conservation. And even though the Constitution doesn't use the term climate change, it is very conscious about what is happening in Nepal as a result of climate change. This being, and as to the directive principle, all of us in South Asia has a common approach. They are not just vacuous jargon. They are there in the law, though they may not be directly implemented by the court. They are policy guidelines which should guide the policymakers and also add vitality to the rights guaranteed. This is the common standpoint of the judiciary, be that Nepal, India, Bangladesh, or Sri Lanka. So after presenting Nepal's constitution and the climate justice roadmap, let me come to your first question. The role of law in securing climate justice. So on this, like the pantheons in legal field, I also take the view that if the law has a purpose, it is justice and only justice. And in the context of challenges to environment, it is justice to humans and the nature. Even though environment and climate change are science-led discourses, law has a significant role to play in securing climate justice because rights, equity, and fairness in the benefits and burden are in sharp focus here. And when we talk about justice, it is not divine justice, but legal justice. Let me take the leaf from Ismat Legari, the case decided by the Pakistani Lahore High Court, where climate justice in the context of climate change is epitomized as, and I quote, a clarion call for the protection of fundamental rights of the citizen of Pakistan, in particular, the vulnerable and weak segments of the society who are unable to approach this court. The court further says, and I quote, climate justice links human rights and development to achieve a human-centered approach, safeguarding the rights of the most vulnerable people and sharing the burdens and benefit of climate change and its impacts equitably and fairly. Climate justice is informed by science, responds to science, and acknowledges the need for equitable stewardship of the world's resources. Coming from the jurisdiction and the judicial culture of South Asia, I'm of the view that if climate justice has a human face, it speaks through the mouth of judges and thrives in the form of rights and obligation. Fair treatment, participation, health and well-being of human and nature, promotion of equity, and mitigation and alleviation of vulnerability, and promotion of good governance. When I say this, I do understand that many things, of course, depend on how the legal system is premised or framed, and what powers are given to the judiciary. But as a student of law, I consider rights as a priori and something supra-constitutional. Therefore, when I look at the constitution and laws of Nepal, beckoning the path towards ecologically sustainable development, this is the expression used in the constitution, in the directive principles of the in the constitution. Through right-based framework, recognizing the need for a healthy environment for the enforcement of rights, my first instinct tells me to make those values realizable. As seen above, the Lahore High Court in Ismat Legari also accorded primacy to human and took a right-centered approach. Secondly, when you talk about the role of law, it needs to be seen in the context of rule of law and the normative order that we are in. The rule of law recognizes the supremacy of the Constitution. It emphasizes that every action of the state or non-state actor should have a legal basis. They should be guided by values of democratic accountability. To further illustrate this, for instance, let's take Article 75 of the Nepali Constitution. It states that the executive power of the Nepal shall, pursuant to this constitution and law, be vested in the Council of Ministers. This provision essentially means the executive draws the power from the Constitution. So, it should respect the Constitution and laws, including the right guaranteed in the Constitution and laws. The executive cannot bypass them while exercising power. At another level, the legislature enacts law based on the Constitution. It is here we see the convergence between rule of law and role it plays concerning the challenges posed, among others, by climate change. Now, with horizontal implementation of rights getting popularity in democratic countries, law can be an effective tool to bind non-state actors as well. They are also required to respect rights of people. It is very much possible to define and determine their space and limits of their activities vis-à-vis the right of the people. Third, I should be brief, I'm likely to cross my time. So thirdly, the law plays the role of positive catalyst and becomes useful in creating awareness, building capacity, setting a standard, prioritizing activities and facilitating the introduction of science, technology and know-how, creating forward-looking and robust institutions and promoting good governance. Fourthly, the role of law becomes even more crucial in addressing non-compliance and omission on the part of the government, which is so palpable in our part of the world. And finally, as understood in the context of South Asia, rule of law is a rule of just, fair, and reasonable law. And in the context of climate change, it is the rule of science-informed law. Where it is not so, and where there is vacuum, the courts can issue mandamus to enact laws for the protection of climate, mountain range, or river system, and civilization based on river system. We have done that in Nepal. Now coming to your second question, can substantive conception of environmental rights make a difference? Let me recapitulate the scenario of 80s and 90s when the Indian Supreme Court began extrapolating rights. In Francis Corelli-Moulin, it gave an expansive interpretation of right. There is a long quotation, and I'll skip this. And right to life was further extrapolated in Subhas Kumar in 1991 to include the right to live in a pollution-free environment. In Nepal, the Supreme Court, in famous Godavari Marble case, said right to environment is intrinsic to the right to life. Other courts in South Asia have also followed this line of interpretation. My brother Chief Justice mentioned about the Mohiuddin Faruqi case, which is a very landmark case in Bangladesh, Sila Zia from Pakistan, in Pakistan, and Ipewala phosphate mining case in Sri Lanka, they have extrapolated right to life to include right to a pollution-free and healthy environment. And the process goes on to include food, water supply, and shelter, education, etc. So these developments by courts have dismantled the vacuum and the different approach to fundamental rights also. Directive principles. So now directive principles are you employ to aid and give force to fundamental right. Now I come to the third question. Okay. Your third question was, does the Constitution have anything to say about green transition? You see, as such, green transition, this terminology was for the first time used in Paris Agreement. That also in the preface of Paris Agreement. In the body part, you don't find anything so worthy about mentioned about green transition. But when you look cumulatively, the pathway taken by Paris Agreement is green transition. And do the court play a role here? On this question, I would like to make a brief submission. The expression, as I mentioned, green transition was not used, is not used in our Constitution. Even then, reading along with the fundamental rights and directive principles, we reach there. While all of them, look at the constitution in South Asia. All the countries declared and have taken constitution as social charters. And younger the constitution, the more the content is there on environment and climate change. Constitution of Afghanistan 2004 talks about ecologically balanced environment. And there are provisions in its directive principle. So does the Maldivian constitution. And the Bhutanese constitution, as my brother mentioned, is so focused, and I'll quote, it requires the state to preserve, protect, and promote cultural heritage of the country. Furthermore, it makes a very bold promise, and it states, and I quote, every Bhutanese is a trustee of the kingdom's natural resource and environment for the benefit of the present and future generation. Protection and preservation and respect of environment and assistance to those in times of natural calamity is a constitutional duty, because disasters so frequently happen in the mountain areas. So this is a constitutional duty mentioned in the Bhutanese constitution. And I spoke about the Nepali constitution, 2015. There are so many provisions in the fundamental right and directive principles, which tells me that the constitution is quite informed about the challenges posed by climate change. Let me emphasize that Nepal's environmental and climate change concerns are more or less explicitly embodied in the Constitution. Therefore, in view of the fact that constitutions have intergenerational dimension and that they are expected to navigate with the present challenges and remain relevant with expanding future, I'm inclined to believe that after carefully calling out the provision of directive principles and fundamental rights, along with the treaty obligation of Nepal, one can trace their resonance to green transition. Finally, coming to the question posed by Professor Pavlos, can a Supreme Court assist the process by providing safeguards of fairness and legitimacy? I'm of the view that motivating factor for any judge to act is the situation of injustice. This is more so in situations created by climate change. Even though much depends on what jurisdiction is given to the judiciary and the Constitution and laws, it also depends on the public trust created by it. Trust is one of the prime considerations for providing legitimacy to the work. Trust is also a cultural issue, which is based on education and training of judges and lawyers and the value they portray in judicial behavior. Even though South Asia does possess a very strong court system, every judiciary has its own approach to justice. No two judiciaries are similar if you very closely observe. For instance, while all the judiciaries are engaged in norm interpretation, a few of them have sometimes been engaged in norm creation in the form of directives and orders they sometimes issue to expedite justice or to secure effective justice. This occurs where there is a legal void or urgency of the matter requires such norm creation. Supreme Court of Nepal and India have sometimes engaged in issuing directive orders and guidelines in order to protect the right of the petitioner or victim till the time executive or the legislature creates rules for the purpose. I do believe that one may find such instances in Bangladesh and Pakistan as well. In recent times, the court have begun to address climate justice, issuing directives on climate justice issues, facilitating green transition in different ways, such as in Ismat Lagari asking the government to implement climate change policy, and in MK Ranjit Singh, the great Indian bustard case, which was decided in 2024 by Justice Chandrachud, which recognized that right to life includes the right to a clean environment and the adverse effect of climate change. This expression is there in the decision. Or Padam Bahadur Srestha or Chakrabahadur Bohra or Sailendra Ambedkar, these are Nepali cases, and other cases coming from Nepal, carving out the principles such as payment for ecosystem service. We said that in the Upper Karnali case. Or ecocide, which is an emerging principle in international law. Now we have used that in the domestic jurisdiction. Or the principle of in dubio pro natura, which my friend Benjamin advocates so much. Antonio Benjamin is the Chief Justice of Brazil. And reveal the possibility of these, in total, reveal the possibility of courts facilitating green transition. While most of the time, pre-existing norms determine judicial behavior, the judiciary, based on emerging dynamics of environment and climate justice in South Asia, I am inclined to believe that judiciary, and more importantly, the Supreme Court can assist in green transition by reviewing the justness and fairness of policies and processes brought out by the state and play more active role in directing the state where there is a void. I thank you for your kind attention.
Thank you. Thank you. And thank you both for this incredibly rich discussions. And I take it from your comments that the answer to the first question is very clear. There is a robust environmental constitutionalism in South Asia. There is, I think, absolute consensus that all courts, in a way, are moving in the same direction. So I just want to ask a question. Am I playing devil's advocate? Perhaps. But let's see the other point of view here. Your comments suggest that human rights, environmental justice, climate justice, in a way, merge. There's one conception of justice that requires us, as it were, to stop human development or to stop industrial development. Now, the traditional way of looking at this, if you go back to justice in a sort of Lockean tradition, is that if you have a piece of property or land and you mix your labor with it, that's Locke's words, then it becomes yours. And there's nothing left. It's yours, your product of your labor. The labor element is what plays the biggest part. I think the theoretical understanding that emerges from both your discussions is that that's actually not true. There is something in nature that's not yours. It can never be yours. It's connected to other species, to other humans, to communities, to the habitat, to processes we don't understand, but we rely on them to survive. So I think there's a philosophical point here. And my question is, maybe not everybody agrees with it. So maybe there's a group in Bangladesh or Nepal or India or Pakistan that says, you know what? I want economic development first. I don't want all these fancy theories about environmental protection. I want to proceed with the shipbuilding project. If there is a little bit of pollution, so be it. We will live with it because we need to feed our children and so on. So there's this economic rationale, the private property growth, the economist's language. So what would you respond to such a critique? Oh, here you are judges, you've got all these lofty moral ideals, but there's a reality of extreme poverty and inequality in our countries. And either it's wrong to forget it, secondly, it's wrong to decide yourselves instead of the political democratic process. What would be your response to this question?
Shall I take
it first?
Yes. I think, with the benefit of hindsight, that the collective thrust of all the rulings that have come forth from our courts of the last 20, 25 years is a paradigm shift of focusing not on the individual, but more to collective rights and collective interests. Because in a country like Bangladesh, with climate migration already a reality, it is something that's happening on a mass scale at a collective level and is impacting the unaffected on a collective basis. And the history of public interest litigation through Muhyiddin Farooq, and I think the experience in India and Pakistan and Nepal has also been the same. The courts have had to step in to assert, frame, inform the content of collective rights in the form of right to life and protection of law, where governance has failed. It is a question of governance. That's how it's started off. And the fundamental or the directive principles of state policy, lofty as they are, education, housing, employment, 50 years into statehood, a generation, 3 generations later, that has no memories of the formation of a state and the strong sentiments of nationalism that form the state. That generation is now saying, what has statehood provided us? Where is independence and statehood taking us from here onwards? And it is a collective demand. And I think of all the organs of the state in South Asia, it has been the judiciary that has always felt the pulse, known the pulse, as it were, and shown the way to the executive and the legislature. And as Justice Bhattarai pointed out, it's not only staying strictly within the constitutional construct of separation of powers. We're always very mindful of not exceeding our constitutional bounds and limits and not arrogating to ourselves the authority to make law. But what we've done through public interest litigation over the years, we've informed the content of future law, invariably. Article 18A of the Constitution was inserted primarily through judicial activism. We informed the amendment of a constitution. So it is collectivism. I think it is, that is where it's headed. And in a post-July, August 2024 Bangladesh, even more so.
Okay. You raise a very important question on property rights, right? So
and the economic philosophy in general, you know, economic development is a good thing in itself. And so
I was a Hubert Humphrey Fellow at MIT, where I studied American property law. And I have studied the property law of South Asia, including my country. There is a paradox in the property law regime. For instance, under American property law, when you have a property right, you have a property right even that goes down even to the underground resources. So if there is petroleum in your property, you are the owner. But when this same property law was extended to India by Britain, the property law and the mining law are different. So the underground resources are covered by mining law, not by property law. Look at the paradox. Second, the concept of parens patriae is a Victorian notion, right? So state is the parent of natural resources. It doesn't work in our part of the world. It doesn't work. In a fragile mountain system, it doesn't work. Rather, state is the trustee of natural resources, guardian of natural resources, and people should be involved in protection of natural resources. This is where the participatory rights comes in, and this is where the notion of inclusion comes in. And secondly, you see, environment and development, although courts are blamed to be anti-development, much depends on how do you interpret development. Is development a product or a process? If we refer to the UN Declaration on Right to Development, 1986, it says development is a comprehensive economic, social, and cultural process which involves people in decision-making and benefit sharing. If that is the case, then you do a fake EIA, a bureaucratic just paperwork, and you start a project. Will the should the court tolerate that? I'll bring in two examples from Nepal. The Nizhgad airport case. For a small country, the Kathmandu airport is very much congested. So we needed another international airport. So this was purported to be a double runway airport, or in the maybe long run, a triple runway project airport. But 8,000 hectares of tropical forest, planning to clear 8,000 hectares of tropical forest. Whereas when you say, look at the Heathrow or the Dallas airport, they may have 5 runways. The court has compared the big airports, right, of 10 big airports, and none of them are more than 3,000 hectares. And here, the government is clear felling 8,000 hectares of tropical forest. And look at the EIA, it says the EIA was first prepared for a hydropower project, and with cut and paste, this was used for an airport project. The court therefore quashed it. So what we have to encounter is bad governance. The motives behind shielding all those bad deeds in the name of development and blaming the court. Thirdly, court has looked into the ecosystem service provided by local people. There is a huge hydropower project coming in the high mountain area in Karnali region in western Nepal. 900 megawatt hydroelectricity project being developed by one Indian company. Now the Indian government has also stepped in. This case came to the Supreme Court. We said, is river just a river or a civilization? Mm-hmm. River Karnali flows from Tibet, crosses the Himalaya and comes to Nepal and goes down to meet Ganga in the Indo-Gangetic plain. There are settlements, human settlements there for thousands and thousands of years, caring about local topography, terrace farming, community forest, orchard farming, all those things. And therefore the river flows so cleanly and in a tranquil and very pleasant way. So should the people not be paid for the ecosystem service they made? This is where court is more perturbed. All the revenue generated from the hydropower projects comes to Kathmandu and later trickle down to the community. No, we said no. People have given ecosystem service, and so this needs to be factored in, and certain % of the revenue generated from the project should go to the community, directly to the community for education, health, and other local entrepreneurship, those sort of things. So we said that. Yeah. This is how we are looking at development. And finally, I come to another very important case, which in the bench, I was one of the judges, and I authored the decision. Look at the Himalaya system. The southern outpost of the Himalaya system is the Churia range. In India, they call it Shivalik. It starts from Pakistan, comes to Himachal, and then enters Nepal and goes to Assam and Arunachal Pradesh, right? Maybe some part of it goes even to Bangladesh. So there was a budget speech in the parliament which said that, okay, in order to meet the revenue deficit with India, trade deficit with India, we'll be exporting sand, gravel to India. If you do that, the hunger that is there for infrastructure development in UP and Bihar of India, even if you decimate the whole mountain range, the hunger will die down. What do? We said, this is ecocide. What you are doing, very consciously, this is ecocide. So we banned export and then asked Parliament to debate on this issue, bring out legislation. Because science has informed us that with GIS and satellite imagery, you can trace out where, like, every river flowing from the mountains brings riverbed material. When it comes to plain area, then that is deposited. So how much to take out from the river? You have to take out some portion of it. But it has to be scientifically done. Yeah. This is the logic we have developed. And this is on the basis we reached to the conclusion that this export to India should be banned. And let the parliamentarian debate in the parliament and bring out legislation. So we have given room for parliament, executive and legislature to deliberate on the issue.
Great. I want to open it up to the audience because we're running very low.